Welcome to Let's Talk U.S. Immigration. Imagine you have done everything right. You got the visa, you booked the flight, and you believe the hard part is behind you. Then you land, tired, and join a queue under bright lights, and an officer you were not expecting flips through your passport. Here is the fact that surprises almost every first-time traveler. Your visa does not actually let you into the United States. It only lets you travel to the border and ask. There's one more door, and today we walk through it together, calmly and in plain language. What the officer is really deciding, why being sent aside for more questions is usually routine, the truth about phone searches, the one panic-driven instinct that undoes honest people, and the simple habit that protects every future trip. Before we begin, everything you're about to hear is designed to inform and educate. Immigration law is complex, and every case is different. What you learn here should always be discussed with a qualified immigration attorney before you take any steps. We are the AI hosts for this series, walking through research carried out on behalf of the team at the law offices of Chris M. Ingram.
Yeah, and I want you to think about the physical sensations of that exact moment. You know, you step off the jet bridge.
Oh man, the air.
Exactly. The air in the terminal is just completely stale. You've been sitting in this, pressurized metal tube for 10 hours.
Right.
Your internal clock is basically screaming that it's 3:00 a.m., your mouth is dry, and you follow these endless sterile corridors.
It's always so much walking.
So much walking. And then suddenly, the carpeting gives way to those hard floors and you hit the arrivals hall and the fluorescent lights are just blindingly bright.
They really are. It's like an interrogation room before you even get in line.
Right. And you hear that sound, the rhythmic thump of the passport stamps echoing off the walls. And there's this quiet, tense hum of hundreds of people just shuffling forward in that serpentine queue.
It really feels like walking into a massive high-stakes exam that, you didn't even realize you had to take. I mean, our mission today for this deep dive is to turn the lights on in that room. We are going to completely dismantle the mechanics of this final door, using all the legal research from attorney Chris Ingram and our legal team.
And because it is a mechanical process, even if it feels random.
Exactly. I want you, the listener, to be able to walk up to that plexiglass booth completely stripped of dread, knowing not just what is happening in front of you, but, the hidden legal machinery running in the background. Because I'll be honest, the central premise here, it feels kind of like a bait and switch.
You mean the idea that a visa isn't actually a guarantee of entry?
Yes. I mean, you go through this incredibly rigorous, invasive process back in your home country. You fill out that massive DS-160 application online.
Which takes hours.
Right, it takes hours. You pay these hefty fees. You take time off work to go down to a U.S. embassy. Sit across from a consular officer, they grill you, and then finally they say you're approved.
And you get the sticker.
You get the highly secure holographic foil sticker printed right into your passport. I mean, it feels like the ultimate green light. Why on earth would the U.S. government design a system where you pass the hardest test, only to find out that it was, just permission to show up for a second test?
Well, it fundamentally comes down to how the U.S. government divides power to protect its borders. It's really about jurisdiction.
Okay, break that down for me.
So the person who gave you that visa and the person looking at you in the airport, they work for two entirely different federal agencies.
Wait, really? I think the average traveler just assumes everyone in a uniform is like U.S. Immigration.
Oh, absolutely. That assumption is the source of so much confusion. But they operate under completely different legal mandates, and they evaluate you at different points in time. The embassy staff who interview you in London or Sydney or Mumbai, they belong to the Department of State.
Okay, the State Department.
Right. And their mandate is long-term eligibility. So they are looking at your life trajectory, your background, your financial stability, and they make a broad assessment. Basically, in theory, this person qualifies to hold a visitor visa for the next 10 years. They are assessing the big picture.
But the officer at the airport is not Department of State.
Correct. The officer in the booth is Customs and Border Protection, CBP.
Oh, okay.
And CBP operates under the Department of Homeland Security. Their mandate is immediate, hyper-specific security and intent on the very second you are standing in front of them.
So it's like macro versus micro.
Exactly. The State Department gave you theoretical clearance maybe months or even years ago, but the CBP officer is tasked with determining your practical reality today for this specific trip on this specific Tuesday.
I'm picturing a highly exclusive nightclub.
I love this analogy. Go with it.
So the State Department is like the event promoter, right? You submit your application to the promoter, they vet your social media, they decide you fit the vibe of the party.
Right, you pass the vibe check.
Exactly. And they mail you a beautiful gold-embossed VIP invitation. That invitation is your visa. It gets you past the outer perimeter, lets you walk up the driveway.
But the promoter isn't standing at the front door.
Right. The bouncer is.
Yeah.
And the CBP officer is the bouncer. The bouncer has absolute unchallenged authority over that specific piece of wood on that specific night.
Yeah, and they do not care that the promoter gave you a ticket 6 months ago.
Not at all. The bouncer is looking at your current state. Like, are you wearing the right shoes tonight? Are you intoxicated tonight? Did you bring someone who isn't on the list?
Exactly.
The bouncer can look at a perfectly valid gold-embossed invitation, look back at you, and say, not tonight, you're not crossing this threshold.
And that analogy holds up perfectly under U.S. immigration law. The legal term for what the bouncer does is admission.
Admission, okay.
Yeah. A visa is merely permission to travel to a port of entry, whether that's an airport, a seaport, or a land border, and request admission. The CBP officer is the only person who can legally execute that admission.
You know, if I'm a traveler and I truly understand that dynamic, it should completely shift how I behave in line.
How so?
Well, if I walk up thinking, I already passed this test, just stamp my book so I can go get my luggage, I'm going to come across as arrogant or defensive when they start asking questions.
Oh, totally. You'll seem annoyed.
Right.
Right.
But if I realize this person is the ultimate bouncer, I have to respect their immediate authority. I have to play by their rules tonight.
And you really have to understand the immense legal weight on that CBP officer's shoulders, too. I mean, we need to talk about a specific piece of the Immigration and Nationality Act.
Yeah.
It's called Section 214B.
214B. Let's break that down. What does that actually say?
So Section 214B mandates that every single alien, which, is just the legal term for any non-citizen who applies for a temporary visa or entry, must be presumed to be an intending immigrant.
Wait, hold on. The law forces the officer to assume you're trying to move to the U.S. permanently?
By default, yes. The legal baseline is guilt by presumption.
That is wild.
It is. The CBP officer is legally required to look at you and assume you are planning to abandon your home country, move to the United States, and never leave. The entire burden of proof rests on you, the traveler, to overcome that legal presumption in the 90 seconds you stand at the primary inspection booth.
I mean, that feels so contrary to how we usually think about the law. The system is literally designed with the default switch flipped to deny.
It is. It really is. So when you step up to that booth, the interaction that our legal team refers to as primary inspection begins.
And for most travelers, that just feels like a blur, right?
Usually, yeah. You hand over your passport, the officer scans it on the machine, you put your fingers on that little glowing green glass plate for the biometric fingerprint scan.
And then they take that lovely, incredibly unflattering digital photograph of your face.
Right, exactly.
But while that's happening, they start asking what feel like these incredibly mundane conversational fillers. Like, why are you visiting the United States? Or how long are you staying?
Where are you going to be staying?
Yeah, and what do you do for work back home?
And here's the thing. Those questions are not conversational fillers. Not at all.
They aren't just making small talk while the computer loads.
Definitely not. They are a highly structured, rapid-fire interrogation designed specifically to overcome that 214B immigrant presumption. Our attorneys emphasize that there are two hidden questions behind every spoken question at the booth.
Okay, let's dissect those. What is the first hidden question?
The first is purely mechanical. Are you really who this piece of paper says you are?
Just basic identity verification.
Right, because the moment the officer scans your passport, a system called APIS, the Advanced Passenger Information System, is communicating with massive federal and international databases.
Behind the scenes.
Exactly. Your fingerprints and facial geometry are being pinged against criminal watch lists, Interpol databases, and records of past border crossings. They are just verifying that you aren't an imposter traveling on a stolen passport or, using an alias.
I assume that biometric technology works so fast now that the identity question is answered in like milliseconds.
Oh, yeah, it is. The computer does all the heavy lifting on identity, but the computer cannot answer the second hidden question, which is entirely psychological.
And what's that?
Do you genuinely intend to do what your visa allows, and then will you actually leave?
Ah, so we're back to intent.
Right. Let's say you have a B2 tourist visa, or maybe you are from a visa waiver country and you are traveling on a Nestor.
Okay, traveling on a Nestor. Got it.
The rules for that are rigid. You are here for leisure, tourism, or short-term legitimate business meetings. You cannot work.
Right.
You cannot enroll in a university. You cannot intend to marry a U.S. citizen and adjust your status to stay permanently. So the officer is constantly probing for any fracture in your story that suggests your intent doesn't match your visa.
Okay, I want to push back on one specific question they always ask, because honestly, it drives travelers crazy.
Okay, let's hear it.
Let's say I live in London. I have a stable life there. I book a 2-week vacation to Orlando to take my kids to Disney World. I have my round-trip tickets. I step up to the booth, and the officer asks, "What do you do for work back in the UK?"
Right, very common.
Frankly, that feels incredibly invasive. Why does my job in London matter to an officer in Florida if I'm just here to ride roller coasters for 14 days?
Because of that 214B presumption we just talked about, the officer has to assume you plan to vanish into the Central Florida economy and never go back to London.
So how do they prove otherwise?
By establishing your ties to your home country.
Ties to your home country. How does asking about my job prove I have ties?
It's basically an algorithm running in the officer's head. They are assessing your risk of overstaying. If you answer, "I am a senior structural engineer at a firm in London," or "I am the head nurse at a hospital," or even "I own a successful bakery,"
Then what?
you are demonstrating profound economic and social gravity. It's pulling you back across the Atlantic. You have a stable career, a significant income, and a life you cannot easily abandon.
Okay, that makes sense.
Right. Statistically, the risk that a senior engineer will throw away their entire career to live undocumented in the U.S. is nearly zero.
So they aren't, like, judging my career choice. They are measuring the strength of the invisible rubber band connecting me to my home country.
The rubber band. That is a brilliant way to phrase it. Yes, exactly. Now imagine a different traveler.
Okay.
They step up and say, "Well, I recently quit my job. I gave up the lease on my apartment. I sold most of my belongings, and I'm just traveling the world indefinitely to find myself."
Oh, boy. The rubber band has been cut.
Completely severed. That traveler has zero economic or social ties compelling them to leave the United States when their vacation is over. They represent a massive overstay risk.
So the officer isn't passing a moral judgment on the digital nomad lifestyle.
No, not at all. They are making a cold, calculated risk assessment based on strict immigration law.
Wow, that really reframes the entire psychology of the primary booth. I mean, if you understand, they are just looking for the data points that allow them to mentally check the low-risk box. It stops feeling like a hostile interrogation.
Exactly. It's just data collection.
Right. You can answer the question about your job calmly, plainly, and without getting defensive, because you know it's actually the key to getting your passport stamped.
And, for the vast majority of people, that is exactly what happens. You answer the questions, the computer comes back clean, the officer stamps the book, and you are off to baggage claim in 90 seconds.
We have to talk about what happens when the stamp doesn't come down.
Yeah, we do.
Because sometimes the officer looks at their screen, their brow furrows, they type a few extra keystrokes, and then they close your passport. They hand it to a different officer. They point to a door off to the side, and they say, "Please follow this officer." You have just entered the most feared territory in international travel.
Secondary inspection.
Just the phrase secondary inspection sounds like you were being sent to the principal's office, but with federal consequences.
It really does sound ominous.
The anxiety in that moment must be suffocating. So let's look at what our attorney's research says about this. Diffuse this bomb for me. What is actually happening when you get pulled out of line?
All right, first let's visualize the physical space. Secondary inspection is usually a large room or a designated waiting area tucked away from the main arrivals hall.
So it's separate.
Very separate. It has rows of uncomfortable chairs, a long counter, and several CBP officers working at computer terminals.
Ingram has been really helpful and professional during the entire process of case preparation and filing. The caseworker was in continuous touch through the process and had put in all the efforts covering the details with evidence against the categories.
There are usually no windows, and there is a strict rule against using your cell phone.
No phones allowed at all.
None. So it feels inherently penal. You feel like you've been arrested. But here is the most crucial reality we can impart to our listeners today. Being referred to secondary inspection is not an accusation of a crime.
Okay, say that again.
It is not a denial of entry. It is merely a time management tool.
A time management tool. Honestly, that sounds far too bureaucratic for how terrifying it feels in the moment.
Well, think about the sheer volume of travel. An international terminal might have 3 wide-bodied jets land within 20 minutes of each other.
Right, that's what, 1,000 people flooding the hall at once?
Easily. And the primary officer has about 90 seconds per person to clear that queue. If a computer system flags something, or if you give an answer that requires a 3-minute explanation instead of a 30-second one, the primary officer physically cannot hold up the line of 1,000 angry travelers to figure it out.
They just don't have the time.
They don't. They must move you out of the flow of traffic.
So they punt the issue to a room where the officers have the luxury of time. Okay, what kind of things actually trigger that punt?
It is shockingly often just a technological hiccup. For example, a name match issue.
A name match issue.
Yeah. CBP relies on the National Crime Information Center, Interpol watch lists, and terrorist screening databases. And these databases often use phonetic matching algorithms.
Wait, meaning they match names that sound similar, not just exact spellings?
Yeah. Yes, exactly. So if your name is David Jones, Maria Garcia, or Muhammad Ali, there is a very high statistical probability that your name phonetically matches someone who has an outstanding federal warrant or a previous deportation order.
Oh, I see.
When the primary officer scans your passport, their screen flashes red, but they don't have the time to pull up the fugitives file and compare your biographical data right there at the booth. So they send you to secondary.
So I'm sitting in that windowless room, sweating bullets, thinking I'm about to be deported, and the officer in secondary is literally just pulling up a file that says the criminal they want is 6'4" with a neck tattoo, and I'm a 5-foot accountant from Leeds.
Precisely. That happens all the time. The secondary officer looks at the file, looks at you, clears the flag in the system, and admits you. It took them 10 minutes, which is time the primary officer simply didn't have.
That is so relieving to hear. Are there other reasons?
Yeah, secondary is also used for completely random compliance checks. Algorithms randomly select a certain percentage of travelers to go to secondary just to audit the effectiveness of the primary screening process.
So you could be pulled out of line purely because a random number generator hit your name.
Exactly. It has nothing to do with you personally.
Let's ground this terror in actual data. I love the statistics provided in the legal research because they completely alter the narrative here.
The numbers are definitely the ultimate antidote to panic. Let's look at the data from a recent typical year of U.S. Customs and Border Protection operations. In one 12-month period, CBP processed roughly 419 million travelers across all ports of entry.
419 million people. That is a staggering number.
Right. Now, out of that massive pool, how many were referred to secondary inspection? About 11.5 million.
Okay, 11.5 million out of 419 million. If we run the math on that, it's roughly 2.7%. Let's round up and call it 3%.
3 in 100. So if you are sitting on a Boeing 777 with 350 passengers, about 10 of the people on that plane are going to be sent to secondary inspection.
That really puts it in perspective.
And of those 11.5 million people who go to the room, the vast, overwhelming majority are admitted to the United States after a short wait and a few clarifying questions.
Knowing that completely changes the psychological landscape of the airport. It takes secondary from being this nightmare deportation scenario and reframes it as just a slightly annoying, slower version of the exact same honest conversation you were going to have at the booth anyway.
Exactly.
If you have nothing to hide, you just sit down, wait your turn, and tell the truth.
That is absolutely the perfect mental posture to adopt. However, we would be doing our listeners a disservice if we pretended the secondary room was entirely benign.
Okay, here we go.
Because while the referral itself is usually routine, secondary is the physical location where travelers are most likely to collide with the most controversial, aggressively debated power that CBP possesses.
The digital border. You're talking about the search of electronic devices, cell phones, laptops, hard drives.
Yes. This is the issue that dominates internet forums and terrifies business travelers and tourists alike.
And it is terrifying. I mean, the stories you read online are chilling. You hear about border agents demanding the passcode to your iPhone, taking it into a back room, and downloading your entire digital existence.
Right. It feels like a massive violation.
Reading 10 years of private WhatsApp messages with your spouse, looking at your camera roll, reading your emails to your therapist. As a citizen of a modern democracy, we are conditioned to believe that our phones are an extension of our brains. They're protected by strict privacy laws. What is the actual unvarnished legal reality of phone searches at a U.S. border?
Okay, the unvarnished legal reality requires us to completely separate domestic law from border law. Inside the interior of the United States, the Fourth Amendment protects you from unreasonable searches and seizures. If a police officer pulls you over for speeding on the highway, they cannot demand to search your phone without a warrant signed by a judge based on probable cause that evidence of a crime is on that specific device.
Yeah, the Supreme Court has been very clear about that in cases like Riley v. California. Our phones hold way too much private data to be searched casually.
Exactly. But the border is a distinct legal geography. Under a doctrine known as the border search exception, the courts have long held that the sovereign right of the United States to protect its territorial integrity overrides standard Fourth Amendment protections.
Meaning the normal rules just disappear at the airport.
Essentially, yes. CBP officers possess incredibly broad statutory authority to search any item entering the country, whether that's a suitcase, a massive cargo container, or a smartphone.
Wow.
They do not need a warrant. They do not need probable cause. For a basic search of your phone, they do not even need individualized suspicion. The mere fact that you are attempting to cross the border grants them the legal authority to ask for your password, unlock your device, and look through your data.
That is a staggering amount of power. So they can just take my phone and start scrolling through my text just because it's Tuesday and I'm at JFK Airport.
Legally, yes. They are looking for evidence of admissibility violations. Let's go back to our tours from London. If the officer suspects they are secretly planning to work, they can open the phone, go to the email app, search the word resume or interview, and if they find emails scheduling job interviews in New York, that traveler is caught.
I understand the law enforcement utility, I really do. But I'm going to push back aggressively here.
Please do.
Even if it is legal, the sheer breadth of that power is deeply unsettling. How is a traveler supposed to remain calm and secondary, knowing that an officer who might just be having a bad day has the unilateral authority to strip mine their digital privacy without a warrant?
I hear that anxiety, and it is entirely valid. It's a scary thought. But this is where the research from Chris Ingram's team provides a vital corrective to the internet hysteria. We have established the terrifying legal reality, right? Now we must look at the statistical reality of how that power is actually applied in practice.
Okay, bring me back to the numbers. Ground me again.
All right, we established that 419 million travelers cross the border in a year. Out of those hundreds of millions of people, how many were actually subjected to an electronic device search?
Give it to me.
Approximately 55,000.
Wait, hold on. 55,000.
Total.
Yep. Out of 419 million.
Run the math again, that is 0.013%.
0.013%. It's basically a statistical ghost. That's roughly, what, 1 out of every 7,000 or 8,000 travelers.
It is vanishingly rare. It makes headlines because it's controversial, but it almost never happens. And our legal team emphasizes another critical distinction. The vast majority of those 55,000 searches were what CBP classifies as basic searches.
Okay, what's the difference between a basic search and the nightmare scenario?
A basic search means an officer takes your phone, unlocks it, and manually scrolls through your recent messages, photos, or emails with their own thumb for a few minutes. They are doing a very targeted spot check.
And the nightmare scenario?
That is an advanced or forensic search. That is where they connect your phone to a digital forensic device like a Celebrate machine and extract the data, recover deleted files, and copy the hard drive.
Right, the stuff you see on TV.
Exactly. Forensic searches are exceedingly rare. Under current CBP directives, an officer generally needs reasonable suspicion of a specific violation of law or a significant national security concern to authorize an advanced forensic search. They don't just plug your phone into a machine on a whim.
I see the strategy here. The traveler's armor is holding both halves of this truth simultaneously. You have to acknowledge that the power exists, so you aren't completely blindsided and outraged if an officer does ask for your passcode.
Exactly. Don't be naive.
Right. Don't travel with documents on your phone that blatantly contradict your visa. But on the flip side, you absolutely should not be sweating through your shirt in the immigration line, assuming your phone is going to be seized. The odds are astronomically in your favor.
They really are. And the danger of obsessing over the phone search is that the fear itself creates a far more present danger. The intense psychological pressure of standing in that secondary room worrying about your digital privacy is what causes honest people to commit the most catastrophic mistake at the border.
The fatal flaw. The dynamic where a perfectly well-intentioned traveler accidentally detonates their own immigration future.
Yes, and it almost never begins with a grand, malicious criminal conspiracy. It begins with the physiological response to stress. When a traveler gets rattled by the environment, their fight or flight response kicks in, and they instinctively deploy what we call a small untruth.
A small untruth. Walk me through how this actually happens in the room. Give me a hypothetical scenario where this goes horribly wrong.
Let's take a very common scenario. A traveler is coming to the U.S. on a B2 visitor visa to spend a month with someone they met online, a romantic interest.
Okay.
They are genuinely just visiting. They have a return flight. They still have their apartment back home. They are legally perfectly entitled to use a visitor visa for this trip.
Right, because visiting a boyfriend or girlfriend is a legitimate form of tourism.
Entirely legitimate.
Yeah.
But our traveler gets pulled into secondary. They are exhausted. The officer asks, "Who are you visiting?" And the traveler suddenly panics. They think, if I say I'm visiting my new boyfriend, this officer is going to assume I'm trying to get married and stay in America forever. They'll deny me.
So the traveler overthinks the 214B immigrant presumption. They try to game the system in their head.
Exactly. They get scared of the truth. So in a split second, they try to smooth over the awkwardness. They answer, I'm just visiting a friend from college. It feels like a harmless simplification to avoid a complicated conversation.
It's a lie.
It is a material misrepresentation to a federal officer. Now, let's say the officer is a little suspicious, so they do a basic manual search of the traveler's phone. They open WhatsApp, and the most recent thread is flooded with romantic messages, plans for the trip, and expressions of love.
The officer now knows the traveler lied.
And here is the tragedy. The underlying truth, visiting a romantic partner, was perfectly acceptable.
They would have been let in.
They would have been. But the law used to cover it up is a catastrophic violation. Under Section 212A PCI of the Immigration and Nationality Act, fraud or willful misrepresentation of a material fact is a permanent ground of inadmissibility.
Wait, permanent?
Yes. If you are found to have lied to gain entry, you can be barred from the United States for the rest of your life unless you qualify for an incredibly complex and difficult legal waiver. The lie destroys you, not the truth.
That reminds me of going to a medical specialist.
Is so.
If you go to a cardiologist and lie about your symptoms because you're embarrassed, you tell them your chest feels a little tight when actually it feels like an anvil is sitting on it, the doctor can't treat you properly. At best, they misdiagnose you. At worst, they give you medication that kills you. At the border, the polished, simple, but false answer is infinitely more dangerous than the awkward, messy truth.
That is the golden rule of immigration right there. CBP officers are human lie detectors. They see thousands of nervous, jet-lagged travelers a week. Nerves do not trigger their alarms. But inconsistencies scream at them.
So if a small untruth is the trap, what actually triggers a hard refusal at the border? Our research outlines 3 main categories for why someone gets put on a plane back home.
Well, let's see if we can deduce them based on what we've discussed so far. We just talked extensively about the mismatch between what your visa says you can do and what you actually plan to do.
Right, so category 1 must be wrong intention, like trying to work on a tourist visa or trying to move permanently on a student visa.
Exactly. If the officer finds your resume or finds an apartment lease in your luggage, your intent violates the law. You are out. The second category flows directly from our discussion of the small untruth.
Inconsistency.
A material inconsistency. This is a fatal mismatch in your narrative across different touch points.
Like saying one thing at the embassy and another at the border.
Precisely. You tell the consular officer in London you are going to Miami for a conference, but when you land in New York, you tell the CBP officer you were here to visit family in Brooklyn. The system relies on you telling the same true story from the visa application all the way to the border booth. If the story changes significantly, you lose credibility and you are denied entry.
So intention and inconsistency. The third category outlined by our legal team is the one that really haunts people, the discovery of past history.
Oh, this is where the ghosts of a traveler's past catch up with them. We are talking about old, undisclosed criminal convictions, even from decades ago. Prior immigration violations, like a trip 10 years ago where you stayed 3 months past your allowed time, or previous deportations or visa refusals that you conveniently forgot to mention on your new application.
And people just hope the computer won't remember. They think, it was a minor arrest in 1998. Surely they don't have that file anymore.
That is magical thinking, and it is a recipe for disaster. Let me be unequivocally clear. The database remembers.
It always remembers.
Always. The information sharing between international law enforcement and CBP is vast and deep. And this brings us to the absolute bedrock piece of legal strategy provided by Chris Ingram's team.
Deal with your history before you book the flight.
Yes. The border booth in a sterile airport is the worst possible legal environment on the planet to discover you have a complicated immigration issue. You are isolated, you are exhausted, and the CBP officer holds all the leverage.
You can't just call a timeout.
No, you can't. If you have an old arrest, even if the charges were eventually dropped, or if you have a history of overstaying, you must consult with a qualified immigration attorney before you travel. They can analyze your record, determine if you were statutorily inadmissible, apply for special legal waivers in advance, and prepare you to answer the officer's questions honestly and legally.
Because if you don't do that prep work, and you stumble into one of these three traps, wrong intent, inconsistency, or hidden history, the consequence isn't just a polite request to turn around and try again later. It's a devastating legal sledgehammer. Which brings us to the hard reality of what a refusal actually looks like.
Right. We need to discuss the mechanism of expedited removal.
Expedited removal. Again, the terminology is deliberately intimidating. Break down the mechanics of this fast-track denial.
So in a domestic criminal context, if the government wants to punish you, you have due process. You see a judge, you have a hearing, you can present evidence, you get a lawyer.
A whole 9 yards.
Right. But expedited removal is a process created by Congress that allows CBP officers to bypass the immigration courts entirely. If an officer determines that you arrived with fraudulent documents, or that you lied to gain entry, or that you clearly have immigrant intent on a temporary visa, they can order you removed from the United States right there in the airport. No judge, no hearing, no trial.
That is an astonishing amount of summary power for one officer to wield.
We attained the Ingram firm for 3 different cases, and they were all successful. The team at Ingram are so professional, on discipline, going above and beyond all details. Aside from being on top of the cases, they all are so lovely and friendly, and very supportive all along through the process. I highly recommend them.
What actually happens in the room during this process?
The officer will conduct a very formal sworn interview. They will take a sworn statement from you, usually recorded on a form called an I-867A and B. They will ask you under oath to explain your intentions and why you lied. Once that order is signed, you are detained in a holding facility at the airport, or sometimes moved to an off-site immigration detention center until a return flight to your home country can be arranged.
But the punishment doesn't end when the plane takes off, does it?
Unfortunately, no. The physical removal is just the beginning. The legal consequence of an expedited removal order is typically an automatic 5-year bar on returning to the United States.
5 years.
You are legally forbidden from even applying for a visa for 5 years. And even after those 5 years expire, you will face massive scrutiny for the rest of your life every time you try to cross the border.
A 5-year ban? I mean, if you have family in the U.S., or if your career requires you to attend conferences in America, a 5-year ban destroys your life.
It is catastrophic, which is why we need to dismantle the Hollywood myth about asserting your rights in these moments.
Well, I'm glad you brought this up. In movies, the protagonist gets pulled into a back room. The agent starts asking tough questions, and the protagonist slams their hand on the middle table and shouts, "I demand to speak to my lawyer. I'm invoking my right to remain silent."
Great dramatic effect, terrible legal advice.
Right. So if I am in secondary inspection sweating over my tourist visa, can I demand legal counsel?
No, you absolutely cannot.
But the right to an attorney is fundamental to the U.S. justice system.
To the criminal justice system, yes. But immigration is civil law. And as we discussed, the border is a unique legal vacuum. The Supreme Court dictates that your rights at the border are entirely dependent on your legal status.
Let's run through the hierarchy of status then. Who has most rights?
U.S. citizens are at the apex. A citizen has an absolute, unalienable right to enter their own country. They cannot be denied entry. A CBP officer can question a citizen, they can search their luggage, they can search their phone, but they eventually have to let the citizen in.
Okay, what about green card holders?
Below citizens are lawful permanent residents, or green card holders. They have immense constitutional protections and a very strong presumption of admissibility, though they can be placed into removal proceedings before a judge if they have committed certain serious crimes.
But what about our audience today? The traveler arriving on a B2 visitor visa, a student visa, or an ESTR waiver.
Temporary visa holders and waiver travelers are at the absolute bottom of the hierarchy. Legally, you are considered an applicant for admission. You are asking for a privilege. You are not exercising a right. Therefore, you have almost no due process rights at the border. You do not have the right to have an attorney present during primary or secondary inspection.
So if I try to play the tough guy and refuse to answer the officer's questions?
The officer will not arrest you for remaining silent. They won't read you your Miranda rights. They will simply say, you have failed to meet your burden of proof to demonstrate that you are admissible to the United States. They will deny your application, cancel your visa, and put you on a plane home.
Wow.
Being combative, testing your rights, or acting arrogant as a temporary visitor is a guaranteed strategy for getting deported.
It's a stark reality check. The only card you have to play is calm, cooperative, absolute honesty.
That is the only strategy. But I want to inject some perspective here. We have spent time in the dark corners today because you need to understand the stakes. But remember the data. Expedited removal is reserved for serious, substantive violations, blatant fraud, hidden criminal history, entirely wrong intent.
Right.
You are not going to be given a 5-year ban just because you stuttered or because you were nervous or because you gave a clumsy answer about your itinerary that you quickly clarified.
Okay, let's take a deep breath. We have mapped the minefield, but the overwhelming statistical reality is that almost everyone navigates it safely.
Exactly.
So let's pivot back to the success story. We survived the booth. We didn't panic. We told the truth. The officers stamped the passport. We collected our bags from the carousel, and we are legally standing in the United States.
It is a great feeling.
It is. But the legal journey isn't actually over. There is one final silent detail. A digital record that, if ignored, will quietly detonate every future trip you try to take.
You are talking about the I-94.
The I-94. What exactly is this, and why do our attorneys emphasize it so heavily?
The I-94 is your official arrival and departure record. It is a digital file generated by the CBP officer the exact moment they admit you into the country. Its sole, critical purpose is to dictate precisely how long you are legally permitted to remain in the United States on this specific trip.
I need to draw a massive bright red line between the I-94 and the visa and the passport, because this is the trap that catches incredibly smart, well-educated people.
Oh, all the time.
Let's say I look at my passport and I have a shiny new B2 tourist visa. The issue date is January 1st, 2024, and the expiration date is January 1st, 2034. It's a 10-year visa. Does that mean I can rent an apartment and stay in Florida for 10 years?
Absolutely not. This brings us full circle to the very first concept we discussed today, the difference between permission to knock and permission to enter.
The bouncer analogy.
Right. The validity dates on that visa sticker, that 10-year window, only represent the lifespan of your invitation. It means you have the right to travel to the border and ask the bouncer to let you in at any point during that decade. It has zero bearing on how long you can stay once you cross the threshold.
So the visa is the lifespan of the invitation. What is the I-94?
The I-94 is the curfew. When the CBP officer decides to admit you, they assign an admit until date. For a standard tourist visa, that is typically 6 months from the date of entry. If you enter on an ESTR waiver, the absolute maximum is 90 days. The I-94 date is the hard, non-negotiable legal deadline for your physical presence in the country.
Let's go back to our analogies. I think of this as the difference between a driver's license and a parking meter.
Walk me through that.
Your driver's license, which is your visa, might be valid for 10 years, right? It proves you are legally qualified to operate a vehicle and drive down the street anytime in the next decade.
Makes sense.
But when you pull your car into a specific parking space, the rules change. The parking meter, the I-94, dictates the rules of that specific space on that specific day. Meter might say you only have 2 hours. If you leave your car there for 3 hours, you get a ticket and your car gets towed. It does not matter that your driver's license is valid until 2034. You violated the terms of the meter.
That is an absolutely flawless analogy, and confusing the driver's license with the parking meter is the leading cause of accidental immigration violations. A traveler looks at their passport, sees the visa expires in 2034, and assumes they can just stay. But if their I-94 admit until date passed last week, they are now unlawfully present in the United States. They have officially overstayed.
And what happens if you accidentally overstay by just a few days? Does anyone really care?
Oh, the law cares immensely. Under Section 222(2)G of the Immigration and Nationality Act, the moment you overstay your I-94 by even a single day, your underlying visa is automatically voided.
Voided, as in the 10-year visa is instantly canceled.
Canceled by operation of law. Furthermore, depending on how long you overstay, you can trigger automatic 3-year or 10-year bans on returning to the United States. A simple misunderstanding of the paperwork can lock you out of the country for a decade.
So how do we prevent this catastrophe? What is the actionable, practical advice for a traveler who just arrived at their hotel?
It's what our legal team calls the 5-minute habit. Historically, CBP used to staple a physical white card into your passport so you could literally look at the date. Today, the process is almost entirely digital and paperless. The officer might stamp your passport with the date, but sometimes they don't even do that. You must actively seek out the official record.
So I get to my hotel, I connect to the Wi-Fi. What do I do?
You open your laptop or your phone, and you go to the official Customs and Border Protection I-94 website. You enter your name, date of birth, and passport number. The system will instantly generate your official digital I-94 record. It is free, and it's the definitive legal truth of your status.
You find the specific admit until date.
You find that date, you write it down, you put it in your digital calendar with a loud alarm set for 2 weeks prior, and you respect it absolutely. Do not play games with the deadline.
So don't book the flight at the last minute.
Exactly. Do not book your return flight for 11:00 p.m. on the exact day your I-94 expires, hoping there isn't a mechanical delay with the aircraft. Build in a buffer. That 5-minute habit is the final act of protecting your immigration record.
It is the ultimate finish line of the journey.
It truly is.
We have covered an immense landscape of legal architecture today. We've gone from the conceptual split between the State Department and Homeland Security, right down to the forensic realities of a phone search. But instead of just summarizing a list of bullet points, I want to zero in on the one realization from our attorney's research that fundamentally changed how I view this entire process.
What stood out to you the most?
It's the realization that the system is not broken when it feels hostile. It is functioning exactly as legally designed. When we talked about Section 214B, that the law forces the officer to presume you are an intending immigrant, to presume you are lying about going home, that blew my mind.
It is a radical shift in perspective.
It really is. The border isn't a customer service desk where they assume you are a valid tourist until proven otherwise.
Yeah.
It is a legal gauntlet where you are presumed guilty of wanting to stay and you have 90 seconds to prove your innocence. Once you understand that the system is legally mandated to be skeptical of you, you stop taking the questions personally. You stop getting defensive. You just provide the data points to clear the hurdle.
That is exactly right. And to build on that, consider what that legal gauntlet actually represents. We spend so much time talking about the logistics of borders, the passports, the algorithms, the queues. But step back and look at the philosophy of it. A border checkpoint is the physical manifestation of national sovereignty.
That's a heavy thought.
It is. The ultimate definition of a nation-state is its ability to decide who is allowed to step foot on its soil. The laws passed in Washington mean nothing if the bouncer at the door doesn't enforce them. When you stand in front of that CBP booth, you are not just completing a logistical step in your vacation. You are participating in the profound physical act of a country defining its own edges. It is the exact friction point where global mobility collides with national security.
That is a powerful way to look at it. It elevates the entire experience from a bureaucratic headache to a moment of intense legal significance. Which brings us to you, the listener. Based on the deep dive we took today into the legal research, what piece of this puzzle surprised you the most? Was it the statistical reality that phone searches are incredibly rare? Was it the realization that your expensive visa is just a knock on the door? Or was it the terrifying ease of accidentally overstaying your I-94? Think about it. And share those aha moments with fellow travelers, because dispelling the myths is the best way to drain the anxiety from the arrivals hall. So let us leave you at the heart of it. Your visa gets you to the final door. Your honesty, your consistency, and a real purpose that matches your visa are what open it. For almost every honest traveler, the border is a quick, ordinary conversation and then a walk toward baggage claim. If you're asked to step aside for a few more questions, stay calm because it is usually routine. Tell the simple truth, even when you are nervous. Never smooth over an awkward detail with a small untruth. Deal with anything tricky in your history before you fly rather than at the booth. And when you arrive, check your I-94 so you know the exact date you must leave. The strategies in this discussion are for educational purposes only. Your situation is unique, and the law offices of Chris M. Ingram are here to help you understand your specific options. If there is anything in your past that could complicate your entry, visit breakthroughUSA.com and reach out for a free consultation before you travel. And if you've not yet been through the visa interview, listen to our 2-part guide on how to prepare and what a refusal really means. Thank you for listening, and we will see you next time.